Okay. Uh, Good afternoon. My name is Palomar Sanchez. I am the one of the staff attorneys for the Richmond Rent program. Today is the Understanding Evictions in Richmond workshop presented by the City of Richmond Rent program. Thank you all for attending. I hope this will be informative, and if there's any questions, feel free to schedule an appointment after you view the workshop so we can discuss any particular questions you may have. First of all, so the City of Richmond still has the Urgency Ordinance 02-21. So on March 23rd, 2021, the Richmond City Council adopted Urgency Ordinance number 02-21, the quote unquote eviction moratorium, establishing a temporary moratorium on certain evictions of residential tenants in Richmond through the local emergency and 60 days thereafter. So this is, it's still law. And even if the city council ends the local emergency, this urgency ordinance will still be in effect for 60 days thereafter. While the urgency ordinance is in effect, landlords are prohibited from evicting tenants in most circumstances. Please review the ordinance on our website if you have any questions. In sum, according to the urgency ordinance, the 3 grounds for allowable evictions while the ordinance is still in place are: 1, a nuisance which poses an imminent health or safety threat, the tenant has failed to pay rent, and or the ELLIS Act, which is to remove the residential real property from the rental market. And there are additional requirements both under California state law and or the Richmond Rent Ordinance for each of the above 3 reasons. For further details, please contact our office to discuss or speak to an attorney. So this is just an overview of the Richmond Rent Ordinance. First, we have rent control. And then there's just cause for evictions. In terms of rent control, that just means that rent are regulated. The maximum allowable rent, which is otherwise known as like the rent ceiling, is calculated by taking the base rent, adding the any annual general adjustments, which is a cost of living increase or otherwise known as inflation, and adding any allowable individual rent adjustment that is ordered by a hearing examiner. And that would be through the petition process, which is in the box below this, a little in the middle. The petition process is a mechanism to increase or decrease the MAR based on reasons permitted by the rent ordinance. Then there's the annual general adjustment, otherwise known as the AGA, which represents 100% of the consumer price index in the Bay Area or the inflation rate. And then there's the base rent, of course, which is the rent in effect as of July 21st, 2015, or the first rent or initial rent charged for tenants that moved in after that date. The other part of the rent ordinance is the just cause for eviction protection section. Essentially, this means that a landlord needs to have at least one of the 8 just causes to terminate a tenancy. The 8 reasons are: 1, failure to pay rent; 2, breach of lease; 3, nuisance; 4, failure to give access; 5, temporarily vacate in order to undertake substantial repairs; 6, owner move-in or owner relative move-in; withdrawal from the rental market, which is otherwise known as the ELLIS Act; and a temporary tenancy, which is a specific eviction only allowable for single-family homes where the owner was previously living there and they want to rent it out for up to 1 year. So which properties are covered by the rent ordinance? First of all, there's fully covered, which means a controlled rental unit, which means that that unit has both rent control and just cause for eviction protection. Such examples are multi-unit properties built on or before February 1st, 1995. Partially covered units is where there are only just cause for eviction protections, but the rent is not controlled and it is unregulated. Some examples of this would be subsidized units, including Section 8 tenancies, properties with 1 dwelling unit and 1 parcel, condominiums, and new construction, which is things that are constructed after February 1st, 1995. And that star or that asterisk below just says that Costa-Hawkins requires units to be permitted with a certificate of occupancy in order for it to be considered new construction. Fully exempt is the final category where there is no rent control and no just cause for eviction protections. Essentially, it's not even in Richmond. Some examples of this are where a landlord and tenant share a kitchen and or a bathroom. Single family homes where a permitted ADU or accessory dwelling unit was added and the main house is owner occupied, or retirement homes. Now, compliance with the just cause for eviction requirements, there are several pieces to this. First is understanding the just causes for eviction, the eviction notice and requirements, and the eviction process. So again, this is the overview of the just causes for eviction under Richmond Municipal Code section 11.100.050. Residential tenants can only be evicted for one of the following just causes, and the notice must state the reason. Failure to pay rent after having been served a 3-day notice to pay or quit. Breach of lease if a tenant continues to violate the lease after being warned in writing to cease the violation. Nuisance if a tenant continues to cause a nuisance after being warned in writing to cease causing the nuisance. Failure to give access if a tenant continues to deny a landlord lawful entry per Civil Code 1954 after receiving a written warrant to cease denying lawful entry. Temporarily vacate in order to undertake substantial repairs. Owner move-in, withdrawal from the rental market or the ELLIS Act, and a temporary tenancy. As you can see, the 3 out of the last 4 just causes have asterisks. And that asterisk means that for those reasons, if any landlord invokes any of those reasons, a relocation payment is required under the City of Richmond's Relocation Ordinance. So the amounts are posted on our website. You can actually view those. There are both temporary and permanent relocation payments. Written warning notice requirements under the Rent Ordinance means or requires that a written warning notice must be served prior to a notice of termination of tenancy if the just cause for eviction is breach of lease, nuisance, failure to give access, or failure to give access. It must provide the tenant with a, quote, reasonable period of no less than 5 days to correct the violation prior to serving a notice to terminate the tenancy. It must state the failure to cure may result in an eviction. It must inform the tenant of their right to request a reasonable accommodation. It shall include the contact number of the rent program. It shall include instructions for compliance and shall include information necessary to determine the date, time, place, witnesses present, and other circumstances. And we do have a template for these written warning notices on our website at the address on the bottom of the screen. Just cause for eviction, the noticing rules under Rent Board Regulation 1001. A landlord must submit a copy of any termination of tenancy notice served on a tenant within 2 business days of serving the tenant, along with a proof of service, which we also have on our website. The termination of tenancy notice should be submitted online at the website on the screen. For properties with 5 or fewer units, the landlord may submit the notice by mail, right? Regular US mail. Failure to file the termination of tenancy notice timely may be asserted by the tenant as an affirmative defense in an unlawful detainer proceeding. We have discussed what is a just cause, but what about what is not a just cause to evict in Richmond? Not just cause. The mere expiration of a lease agreement, especially where the contract says the tenant must move at the end of the lease. Not just cause. The sale, transfer, or foreclosure of the property. Not just cause. The tenant is paying below market rent and the landlord wants to evict the tenant to reset the rent to market level. Not just cause. If the landlord makes a unilateral change, meaning a one-sided change to the term of the tenancy and the tenant violates that unilaterally imposed term. And finally, what is not a just cause, or the final example, is if the landlord unreasonably denies a replacement roommate, meaning a one-for-one replacement, and then tries to evict for subletting or subleasing. Here are some rent-related resources for landlords and tenants. So we have a COVID-19 rental-related information page, and that is there on that address, the first one. To view, we also have a Richmond Rent Program fact sheet regarding local and state laws concerning evictions and other related matters during the COVID-19 pandemic. There are two websites to visit to see this document. One is in English and one is in Spanish. We also have some rent assistance resources. In response to the COVID-19 pandemic and its economic fallout, many local organizations in Richmond, California are creating or expanding rental assistance programs to support individuals and families impacted by the pandemic. To view the Richmond Rent Program's Rent Assistance Resource webpage, please visit the website on the screen. And there is a list of local organizations providing rental assistance. However, to determine or understand what their process is and if they have funds at the time that you contact them, you just must ask because it varies. Okay, so here is the a chart which, you know, if you follow it, it's a flow chart to explain in a nutshell the process of an eviction. Now, obviously, evictions are complicated. It is a court process and proceeding. You do have judges and lawyers involved, so things can get quite a bit more complex, but this is just to give you a snapshot. So if you start on the top left corner, the tenant has failed to pay rent. Then the landlord serves the tenant with a notice to pay rent or quit. After that, the landlord must file, or maybe concurrent with that, they must file a copy of that notice with the rent board within 2 business days of serving the tenant. Failure to do so is a defense to an eviction lawsuit. Now then the tenant can fail to pay rent within the noticing period. And then the landlord files the unlawful detainer in court, which is the eviction lawsuit. So then that tenant must respond with their affirmative defenses to the eviction lawsuit within 5 days of having been served with suit. Now, they can either respond or not. And if they fail to respond, then the landlord can file a request for what's called a default judgment. And if approved, that default judgment is entered against the tenant. If that tenant does not move voluntarily, the landlord can ask the court to issue what's called a writ of possession, which they can take to the sheriff or the police. And then that sheriff or police will serve the tenant with a notice to vacate. And after that notice ends, the sheriff evicts the tenant or they're escorted from the property. Now, if the tenant does respond and files what's called the answer with those affirmative defenses within the 5-day deadline, the court will mail notice of the hearing or trial date. And then there's usually some dates and items that happen in between then. But again, this is just a snapshot. But essentially after that, a judge or a jury trial will be held where either the tenant prevails, where they can retain possession of the unit, or the landlord prevails, where they are awarded possession of the unit. Remember, the only issue in an unlawful detainer is possession of the property. Now, in most cases, and the third option, as you can see in the bottom left corner, is settlement. This is very common for unlawful detainers, and so be prepared that that may be on the table. Okay, so now we are at what's called no-fault evictions. This includes owner move-in and withdrawal from the rental market, otherwise known as the ELLIS Act. So evictions for owner or owner relative move-ins. This is where the owner wants to recover possession of the rental unit as a primary residence for the owner's spouse, children, parents, or grandparents. And so those listed family members are the only people where an owner can do an owner move-in, or more appropriately called an owner relative move-in. They can only do it for their spouse, children, parents, or grandparents. And I think registered domestic partner also works. An owner in this section is considered an actual person who has at least 50% recorded ownership And an eviction for an owner move-in cannot occur if the same owner or chosen relative already lives in a unit on the property, or if a vacancy already exists on the property. At all times, an owner can request a reasonable accommodation if the owner or chosen relative is disabled and another unit is necessary to accommodate the person's disability. And finally, tenants have a first right of refusal to return to that unit if the rental unit is ever placed back on the market. So again, the part of this is that they stay, whoever moves in stays there for 3 years, but subsequent to that, after the 3 years, if they decide to rent it out again, that unit has to be offered back to the previous tenant. The tenant must be served with an owner move-in notice, which is a termination of tenancy, and usually owner move-in forms may be downloaded from our website. The owner must give the tenant at least a 60-day written termination notice if the tenancy has been in place for more than 1 year. If it hasn't, then it's only a 30-day notice. Within 2 business days after serving the tenant a termination of tenancy notice, the landlord must file a copy of that notice with the rent board with the completed proof of service. Failure to do so renders the notice of termination null and void. And it could be used as a defense in the unlawful detainer proceeding. So these are the requirements of an owner move-in. The person moving in shall move into the rental unit within 90 days after the tenant vacates and must occupy the unit as a primary residence for at least 36 consecutive months. The owner must pay 1/2 of the applicable relocation payment within 3 business days after the tenant has informed the owner in writing when the tenant plans to vacate the unit, and the remaining half is due within 3 business days after the tenant has vacated the unit. If the owner or chosen relative fails to occupy the unit within 90 days after the tenant vacates, the owner shall, 1, offer the unit to the tenant who vacated, and 2, pay the tenant all reasonable expenses incurred in moving to and from the unit. In the last slide, I talked about the tenant possibly moving back to the unit. Now, if it's a rent control property, if the tenant moves back to that property, or it's the first intervening tenancy, the rent charge must revert back to the level paid by the displaced tenant, and the owner may be eligible to apply applicable annual general adjustment rent increases. The landlord must provide the tenant with proper noticing requirements for these rent increases. Now, in a non-rent controlled property, such as a single family home, for example, if the tenant moves back to the property, the owner may apply rent increases. And landlords are not restricted to the AGA rent increases. Essentially, they can raise the rent to market. However, the landlord must provide the tenant with proper noticing requirements for the rent increase. There are some protections for seniors or disabled persons from owner move-in eviction. An owner may not evict through owner move-in if the tenant meets the following criteria. 1, they have resided in the rent unit for at least 5 years. And 2, they are at least 62 years of age, disabled, or are certified as being terminally ill by the tenant's treating physician. And if there are multiple tenants, only one tenant needs to be any one of these designations, 62 years of age, for example. An owner may evict a tenant who is protected if the owner or chosen relative also meets the same criteria and no other units are available. Essentially, the owner can override these protections if, for example, they want to move in their mother, and that mother is senior or disabled. The ELLIS Act. So this is different from the owner move-in. This is called the ELLIS Act, which is otherwise known as withdrawing from the rental market. So the ELLIS Act is a California law, Government Code Section 7060 to 7060.7, and part of the Richmond Rent Ordinance that provides, and part of the Richmond Ordinance that provides landlords with a legal way. I misread that. And it is part of the Richmond Rent Ordinance that provides landlords with a legal way to go out of the rental market business. The ELLIS Act was adopted by the California legislature in 1985 after the California Supreme Court decision in the case of Nash v. City of Santa Monica. For more information and detailed steps, please visit the website address on the screen. Now, these are the notice requirements for an ELLIS Act or withdrawal from the rental market. The tenant must be served with a written notice for withdrawal from the rental market, which is a termination of tenancy. The owner must give the tenant no less than 120 days for the tenant to vacate the property if there is not a qualifying tenant who lives in the household. The owner shall provide a written notice to each tenant on the property, notifying them of the withdrawal from the rental market. Tenants shall be entitled to a 120-day notice unless they are qualified tenants. Qualified tenants are entitled to a 1-year notice if they are senior, disabled, and this is what a qualified tenant means. They have to be senior, disabled, have at least one dependent minor child, or the entire household is considered a low-income household. And they have to have been residing in the unit for at least 1 year prior to the date of the delivery of the notice of intent to withdraw to the board. If the qualified tenant wants the 1-year entitlement, within 60 days of the date of delivery of the determination notice to the rent program, the qualified tenant must return to the owner a notice of entitlement to the 1-year notice. Now, returning withdrawn rental units back to the rental market. For rent control properties that are being withdrawn from the rental market and are rented again after withdrawal, the following applies. So there are restrictions. If the property is offered for rent within 2 years from withdrawing from the rental market, the owner shall be liable for actual and punitive damages to any tenant displaced by the property being withdrawn. And 2, they must offer the unit back for rent to the displaced tenant. And this is only if the tenant has that asterisk there, is only if the tenant has advised the owner in writing within 30 days of his displacement of his or her desire to consider an offer to renew the tenancy and has furnished the owner with an address to which that offer is to be directed. So again, essentially what that first part is saying is that if a landlord, that it's essentially prohibited to rent at all within the first 2 years. And if they do that, then that landlord will be liable to the displaced tenant for damages. For rent control property tenancies only, for the first 5 years after withdrawing the unit, if the property is reoffered for rent, the property shall be offered back to the vacating tenant at the rent in effect when the property was removed from the rental market. An annual general adjustment rent increase may be applied if the tenant moves back into the rental unit. For non-rent controlled tenancies, the landlord must still offer the unit back to the tenant who is evicted. However, the rent charge can be set at market rate. If the property is demolished, reconstructed, or offered for rent within 5 years from the withdrawal of the market, the newly constructed unit shall be subject to rent control. If the property is offered for rent within 10 years from withdrawing from the rental market, the owner shall notify the rent board and offer the unit back to the tenant who is evicted. Tenants have a first right of refusal to return if the rental unit is placed back on the market. The City of Richmond's Relocation Ordinance. So I alluded to this when discussing owner move-ins and ELLIS Act, but this is just more of a display of the exact numbers. So first of all is the temporary relocation payment. Landlords must provide temporary relocation payment assistance when the tenant must temporarily vacate for the landlord to undertake substantial repairs, or if there's a governmental order to vacate the unit, or if the tenant is merely just forced to vacate due to the condition of health and safety in the unit. The notice of entitlement to temporary relocation payment must be provided with the notice of termination of tenancy, should there be one, and relocation of payment amounts are determined by a resolution of the City Council. So here are the amounts for 2022, which are subject to change in 2023, obviously, but currently these are the amounts for temporary relocation payments. So for hotel and motel, It's $168.15 per day per household. Meal expenses are $33.85 per day per person. And laundry is $1.12 per day per household. And pet accommodations, meaning if that the hotel, wherever the tenants are staying, that they don't allow pets, so that the pet has to be boarded, the amounts are as follows. It's for a cat, it's $32.73 per day per animal. And for a dog, it's $58.69 per day per animal. So these are the permanent relocation payments. We were just talking about temporary. These are now permanent. So these must be provided to tenants whose tenancy is terminating due to owner move-in or owner relative move-in, or withdrawal from the rental market, or under extenuating circumstances due to governmental order to vacate or health and safety conditions, which are far less common. The notice of entitlement to relocation payment must be provided with the notice of termination of tenancy for owner move-in and withdrawal from the rental market. And the amount is determined by a resolution of the Richmond City Council as follows. So for owner move-in, it depends on how, what type of unit, how many bedrooms, and also if there's two amounts, base amount and the qualified tenant household amount. Again, qualified tenant household simply means that at least one tenant is a senior, which is, I believe, 62 years of age or older, disabled, or has at least one minor dependent child. And so if you're any of those, then you get the higher qualified tenant household amount. So for a studio, the base amount is $3,940.58. The qualified tenant household amount is $4,578.17. For a one bedroom, it's the base amount is $6,084.66. The qualified tenant household amount is $7,011.12. For a unit that has two or more bedrooms, the base amount is $8,286.28. The qualified tenant household amount is $9,502.77. Now, next is withdrawal from the rental market amounts. So again, it's the same breakdown in terms of bedroom and base versus qualified, but the amounts clearly are much higher. So for a studio, the base amount, again, under the ELLIS Act is $7,938.72. And the qualified tenant household amount is $9,097.64. A one bedroom is $12,169.33. The qualified tenant household amount is $14,023.37. And a unit which has two or more bedrooms is the base amount is $16,515.02. And the qualified tenant household amount is $19,006.65. Okay, so these are just some general important tips on evictions. First of all, a self-help eviction is when a landlord locks a tenant out, cuts off utilities, or otherwise takes their own action to terminate the tenancy without going to court. Self-help evictions are illegal in California. Thus, a landlord must proceed with the unlawful detainer or eviction lawsuit process and receive a judgment from the court. If the tenant does not vacate, the sheriff can evict with a writ or judgment in their possession. So again, just to emphasize, self-help evictions are completely illegal, cannot lock tenant out, cannot cut off the utilities, you cannot put their stuff on the street. That would subject that landlord to all kinds of liability. The second point is, which is bolded and underlined, is probably the most important part of this entire workshop, which is you need to speak to an attorney. Evictions can be highly technical. It is highly recommended to consider speaking to legal counsel to better understand the process and current law, especially with what's going on with the pandemic and what we've been discussing, and to possibly have the attorney represent you in court. Learn about tenant and landlord responsibilities and educate yourself about both California and Richmond eviction laws. No-fault evictions such as owner move-in and withdrawal from the rental market are complicated. No-fault evictions require special noticing, permanent relocation payments, and may provide special rights to the tenant, such as the right to move back in at the rent paid when the tenant vacated the property, and protected status for qualified long-term tenants. Take eviction seriously. Contact the Richmond Rent Program as soon as possible if you receive threats of eviction, warning notices, actual termination notices, or court documents for unlawful detainer, or if you're a landlord, and you should contact the Richmond Rent Program if you are considering issuing any of these notices or documents. The eviction process has firm deadlines, which, if not met, can lead to the tenant being evicted. If an unlawful detainer, it can also lead to the case being dismissed if you're a landlord and you miss these deadlines. If an unlawful detainer complaint is received, tenants generally only have a certain amount of days to respond with an answer to the unlawful detainer. If a tenant does not file the answer to the unlawful detainer with the court within the allowed time, the judge may enter a default judgment against the tenant. Finally, be a tenant. If you're a tenant, be a tenant in good standing. Prior to just cause eviction protections in Richmond, tenants could be evicted without cause. Tenants should avoid giving the landlord a just cause reason to evict if they can. Thank you very much. I really appreciate everybody's participation and attention to this workshop. I hope you learned something. However, if you have questions or something was unclear, feel free to contact our office, the Richmond Rent Program, at 510-234-7368. You may also send us your question by email by sending an email to rent@ci.richmond.ca.us, or visit us at our website at www.richmondrent.org. Thank you so much. Have a good day.